Oh yay, oh yay, oh yay, this Honorable Court of Appeals of Tennessee is now in session.
Dare I say we'll hear the cases in the order that they appear on the docket today. Thank you for coming. You'll have our sole and undivided attention. And unless there's any announcements, and seeing none, would you call the case, please?
Barron Construction, LLC versus 4J Construction Company, Incorporated, et al.
Good morning.
Good morning.
May it please the court, I'm Noble Grant from the Madison County Bar Association, and I represent the Appellants, 4J Construction Company, Push 4J, and Lafayette Johnson in his individual capacity. It's a pleasure to be with you this morning.
Do you want to reserve any time?
I would like to reserve 2 minutes for rebuttal argument.
2 minutes?
2 minutes.
Okay.
Now, we are before the court today on the appeal of a decision that involved a lawsuit alleging a breach of contract. This was a contract between a contractor, a prime contractor, and a subcontractor, my clients being the subcontractor. They were hired to perform concrete services for the construction of an E911 building near the area. At some point during that relationship, things deteriorated, and my client was terminated from the job, and Barron Construction filed a lawsuit against my client, alleging that a number of things, but in essence that my client had breached the contract. It's important to note that my client denied in my clients denied in their answer many of the allegations against them, and also alleged a counterclaim for breach of contract against Barron. Notably, in that counterclaim, my clients alleged that Barron had failed to pay them according to the terms of the contract. They also submitted that they had diligently performed their obligations under that contract.
Now, when you say they, are you referring to Push 4J and 4J?
Yes.
Okay.
I am referring to...
So they were both asserting counterclaims?
Yes. All three defendants
okay. Mr. Johnson was as well. Okay.
Asserted counterclaims against Barron Construction.
And the subcontract itself was between the plaintiff and 4J.
Correct. So
how did Push 4J relate to the overall project?
So Mr. Johnson is the sole member, or was the sole member of 4J Construction. 4J Construction was during this litigation, or during the period of this contract, 4J Construction was administratively dissolved due to failing to pay, I believe it was some type of state revenue tax. I think it was unemployment insurance premiums, to be exact. So my client formed the LLC Push 4J Construction and began operating under Push 4J Construction. Now, I will concede that the contract with Barron was with 4J Construction Company, Inc., not Push 4J Construction.
So LLC sort of took over the responsibility of 4J.
It did.
Okay, I see.
It did, yes. But in any event, my clients did allege these counterclaims against Barron, and Mr. Johnson, being a one-member LLC with Push 4J Construction and a one-member corporation with 4J Construction, was doing all he could to finance this litigation. Unfortunately, it got to a point in January of 2020 where the trial court, I guess, felt like it had given Mr. Johnson all of the chances that it could, and dismissed his counterclaim and granted a default judgment. But prior to that, Mr. Johnson had consistently advised the court that he was diligently trying to retain counsel. Each time that one lawyer would bail on him because he had failed to pay him, he would advise the court, I'm trying, having some financial difficulties here, but give me a little more time. And the court, to a point, granted those requests. But again, like I said, in January of 2020, the court dismissed his claims and granted a default judgment against him. Shortly thereafter, he was able to secure financing to retain another attorney. That attorney filed a motion to alter or amend the order that dismissed those claims and granted a default judgment. And the trial court vacated its order and gave Mr. Johnson another chance. Now, after that, that attorney withdrew, again, for Mr. Johnson's failure to pay. That was, I believe, the primary basis for that motion to withdraw. At that time, there was already a jury trial set, I believe it was a 3-day jury trial set in February of 2021. Mr. Cadle was allowed to withdraw by order entered, I believe, on August the 4th of 2020. So we're 5 months away from a jury trial. The very next day, the trial court gave Mr. Johnson 30 days to hire a lawyer. He was unable to do so. The trial court held a hearing on a motion for sanctions and for a default judgment in October of 2020, at which time Mr. Johnson had not been able to secure counsel yet, and the trial court granted a default judgment, dismissed Mr. Johnson's claims, his counterclaims again, and the LLC and the corporation's counterclaims again. And it's interesting to me, the timing of that, because there was a jury trial that was scheduled, and there were, this happened in early October, so Mr. Johnson had roughly 4 months at that time to secure counsel to represent him at a jury trial. And ultimately, he did end up retaining myself. And I feel that the trial court, jumped the gun. The trial court had been, it's undeniable, the trial court had been gracious to the defendants throughout the litigation, but I feel like the trial court jumped the gun when there was a jury trial that was a few months away, and the trial court should have given Mr. Johnson time. And
counsel, what is this court's standard of review in reviewing that determination by the trial court?
It's an abuse of discretion standard.
Wasn't the chancellor within her discretion in this case? I mean, maybe another judge would have made a different decision, but wasn't she within the scope of her discretion?
I don't believe she was. Given the timeline of events, I don't believe she was. I think the court abused its discretion by acting, by the timing of its actions. And not only that, the appellees have raised in their brief that Mr. Johnson and the corporate defendants did not raise a meritorious defense, and that's simply not true. There was an answer filed by the defendants in September of 2017, where they do allege that Barron had failed to pay as they were supposed to pay under the terms of the contract. They do allege that 4J had diligently performed its obligations. There was also mention of meritorious defenses in the motion to alter or amend that was filed in the spring of 2020. And so those defenses included that Barron had wrongfully terminated the contract, and that the defendants were entitled to lost profits, and that Barron was owed money for work, or that the defendants were owed money from Barron for work that was performed.
Did Mr. Johnson file any response to the final sanctions motion in his pro se capacity?
He did not file a response, but I would submit to this court that is a local rule requirement. That is not a rule, as this court is aware, that's not a requirement under the rules of civil procedure.
Is it inconsistent with any rule of civil procedure?
I believe to grant a default judgment based on the failure to file a response that is required by a local rule, I would submit to this court that is inconsistent.
What rule would you point to as that local rule being inconsistent with? What?
I would point to the absence of a requirement under the rules of civil procedure.
Aren't local rules just supposed to fill in gaps that the court's rules?
Local rules, I feel that local rules are important to certain discovery requirements. I feel that in order to rely on a local rule to impose the harsh sanction of a default judgment and a dismissal of claims, I feel is an abuse of discretion. And I feel like that is inconsistent with the rules of civil procedure in that a response is simply not required.
Did Mr. Johnson attend the hearing on that sanctions motion?
He did attend the hearing. He just did not file a response. So, in sum, we do feel that the trial court abused its discretion and should have given the defendants an opportunity to retain counsel prior to this jury trial to allow them a trial on the merits. That's what our system favors. Our system does not favor a decision that is not based on the merits of a case. And Mr. Johnson and the corporate defendants were denied that opportunity. I do believe that it was an abuse of discretion to impose the harsh sanction that the trial court imposed. The trial court did grant some relief on a second motion to alter amend that was filed, but it only granted relief to Mr. Johnson in his individual capacity. Appellees, Barron then filed a motion for summary judgment asking the court to pierce the corporate veil, and the trial court granted that motion and basically undid everything that the relief that the trial court had granted just months earlier. And there is no, the record is absent of any fraud. Yes, I would concede that several of the Allen factors applied to piercing the corporate veil in favor of Barron, but you also have to have a fraud or injustice, and the record is simply absent of any fraud or injustice that would be necessary to pierce the corporate veil. So we also submit that the court abused its discretion by piercing the corporate veil. So we're asking that this court vacate the trial court's order and allow the defendants their opportunity at a trial on the merits of this case as had been demanded.
Thank you.
Morning, Your Honors. Ross Hutchison on behalf of the Appellees, Barron Construction. And I'll quickly run through a brief history of this dispute. It dates back to November of 2015 when Barron Construction entered into a contract with 4J Construction Company, Inc. They were going to build an emergency response center over in Sumner County. And unfortunately, things began to unravel almost immediately. Indeed, at the time of the contract, 4J was not even a going concern, and the only reason that Mr. Johnson utilized 4J Construction, Inc. On those bid documents was that was the only way he could bid on the job. It was determined that during the course of the work under the contract that Mr. Johnson immediately began to divert funds to his personal accounts to pay off personal loans.
And when you say divert funds, were those funds that Barron was paying
he began
pursuant to the subcontract?
Yes, Your Honor.
Okay.
And it was later determined that 4J and Push 4J were merely extensions of Mr. Johnson, and they were never operated in any type of separate capacity. Indeed, what Mr. Johnson was doing was utilizing 4J, Push 4J interchangeably, insurance documents, bid documents, suppliers who would no longer work with one or the other entity. He was just using these entities interchangeably to push the work forward. And the court agreed. The court found that Mr. Johnson did not treat himself separate from these entities. And indeed, Mr. Johnson agreed. He stated himself they were all one and the same during his deposition. As discussed in a moment, the trial court ultimately agreed, finding that the corporate defendants were operating as mere instrumentalities of one another, and ultimately allowed Barron to pierce the corporate veil following summary judgment. Now, for the tortured history of this case, I think it's important to walk through this, and there's some issues with 4J's representation of the facts, and one key fact in particular that we'll get to. But after the contract unraveled, Barron had to complete 4J's work and ultimately sued the appellants on December 16, 2016. On January 18, 2017, appellant's first attorney entered a notice of appearance. So we're on attorney number 1 there. In less than 6 months, appellant's first attorneys withdrew, citing an inability of appellants to pay for counsel, or did not cite an inability to pay for counsel. Instead, they said to fulfill obligations. So there's nothing there indicating a failure to pay. Next, the trial court gave the appellants 30 days to obtain new counsel, and on the 31st day, Mr. Johnson requested an extension. And almost 60 days later, Dr. Bede and Yewu entered on behalf of the defendants. So we're on attorney number 2. Thereafter, and approximately 10 months after the filing of the complaint, the appellants did file their answer and a counter complaint. That was on September 29th of 2017. After discovery and failed attempts to resolve, on June 12th of 2019, Barron sought Rule 11 sanctions in relation to a particular counterclaim that the defendants had brought in relation to a racial discrimination claim. They were never able to provide any type of support, and ultimately that became an issue that was kicked on summary judgment as well by the trial court. The court further, at that hearing in relation to the Rule 11 sanctions on discovery, the court cautioned the appellants, if further abuse of the discovery process occurs, the court will take the totality of their handling of the proceedings into consideration upon such motion. Then on August 13, 2019, counsel for the corporate defendants and Mr. Johnson again filed a motion to withdraw. And here, the cited reason for withdrawal was a failure to pay and an inability to represent Mr. Johnson's racial discrimination claims that could not be supported. On September 13, 2019, the court heard the motion to withdraw and provide Mr. Johnson and the corporate defendants 45 days. 1 week before that deadline to obtain new counsel, Mr. Johnson sought an extension, and the court allowed it again. On October 25th, 2019, the court entered an order and stated that the court will not grant any further extensions on this deadline to obtain new counsel. Mr. Johnson and the corporate defendants then provided this court with a letter 2 days before the pending deadline asking for additional time. On December 5th, 2019, Barron filed a motion to impose Rule 1606 sanctions as the court had previously cautioned Mr. Johnson and the corporate defendants that no additional extensions would be provided. And they had not even had counsel for 3 months at that time. Trial court again provided grace to the appellants, giving them another 30 days, as the appellants had indicated that they would be hiring Miss Elizabeth Tipping. So that's the third attorney that the appellants have now represented to the court, would be representing them. On the day of the expiration of the December 16, 2019 order, the appellants again sought another extension. And on January 16, 2019, the trial court denied this request, as it previously had warned that it would do. On January 27, 2020, upon hearing Barron's Rule 1606 motion, trial court ordered the only claims between Barron and Mr. Johnson that would survive, only allowed the claims between Barron and Mr. Johnson to survive. She kicked the corporate defendant's claims and defenses. On the same day, the appellants proceeded to file with the trial court another request for an extension. And nearly 2 months later, March 19, 2020, Mr. Johnson obtained new counsel, Mr. Jeff Cadle. So we're on attorney number 4. The corporate defendants then petitioned the trial court to reopen their claims and defenses. On April 6, 2020, the trial court vacated its previous order reinstating the corporate defendants and their claims and defenses. Thereafter, Barron sought and granted permission, and it was granted permission to amend its complaint. Therein, we brought additional claims to pierce the corporate veil. No answer was filed on that amended complaint until after the motion to alter and amend had been heard. After 3 months' time, on July 17, 2020, counsel for Mr. Johnson and the corporate defendants withdrew, this time citing a breakdown in communication and failure to abide by contractual obligations. Mr. Johnson failed to appear at the hearing in his individual capacity or on behalf of the corporate defendants. And in this instance, again, there was no mention of appellate's inability or unwillingness to pay fees specifically. On August 5th, 2020, and allowing Mr. Cadle to withdraw, the trial court gave Mr. Johnson and the corporate defendants 30 days to obtain new counsel. And then on September 16th, Barron filed another motion to impose Rule 1606 sanctions. Now, this is where I wanted to clarify some of the facts. On October 2nd, 2020, the trial court held that Mr. Johnson and the corporate defendants had not displayed appropriate respect to the trial court and the processes thereof at a significant detriment to Barron. Now, at that hearing, Mr. Johnson did not appear. No one appeared on behalf of the corporate defendants or Mr. Johnson. He did not file a response. The corporate defendants did not file a response. What Mr. Johnson did do is later show up to the damages hearing in his individual capacity. Corporate defendants were not there, but Mr. Johnson did show up in his individual capacity. And ultimately that day, a judgment was determined and awarded to Barron. Now, approximately 30 days after this hearing.
Is there a transcript from the damages hearing?
I believe there is, Your Honor. I'd have to go back and review. Approximately 30 days after that hearing, Mr. Noble Grant entered, and so we're on attorney number 5, and he filed this motion to alter or amend that's subject to this hearing. And on May 5th, 2021, following a hearing on the same, the trial court granted in part and denied in part appellant's motion to alter or amend. There, the court determined that Mr. Johnson could have proceeded in his individual capacity and was not in violation of any orders. But ultimately, the corporate defendants had failed again to obtain counsel and stay consistent with the orders of the court. So she allowed Mr. Johnson to proceed in his individual capacity. Thereafter, the trial court was focused on a more narrow scope of issues, specifically whether or not to impose personal liability on Mr. Johnson in relation to the breach of contract between Barron and 4J, as well as the extension to push 4J. But then also whether or not Mr. Johnson's allegations against Barron in relation to the racial discrimination claim would survive. With those narrowed issues, Barron filed a motion for summary judgment and was successful. And on March 9, 2022, the court determined that Barron was entitled to summary judgment and allowed Barron to pierce the corporate veil, imposing its judgment that it had previously obtained against 4J in relation to Mr. Johnson and Push 4J.
Counsel, Mr. Johnson emphasizes inability to pay, financial challenges in terms of securing counsel. What factual findings, or if any, does the trial court make that are inconsistent with that in terms of an explanation of his failure to meet deadlines or comply? Or are there any factual findings inconsistent with that?
Your Honor, I see no factual findings that are inconsistent with that necessarily. But what I would point out to the court is that there's nowhere in the record, there's no supporting affidavits, there's nothing indicating, there's no actual proof that this was based on a financial inability to pay counsel. And the court's reasoning, the court attempted to give 4J, Push 4J, and Lafayette Johnson a number of opportunities and encourage them to do whatever was possible to do that. And something that is a little bit strange in this case, that the trial court specifically spoke to in one of its orders, was the fact that Barron in open court indicated a willingness for a complete walkaway, given its concerns of ability to recover, the solvency of these entities. But they couldn't outright do away with the case because of the counterclaim, and the defendants would not release their counterclaim, and so the case survived. And so the court was very frustrated by that fact, in addition to the ongoing failures to adhere to the court's orders. But specific to whether or not there's anything in the record as it relates to the inability to pay, that's only something that's been created by Mr. Johnson in argument after the fact. I don't see anything else in the record that would indicate, and I don't see where the court necessarily relies on anything in relation to that inability to pay.
But counsel, was that raised at any point in objection? Is there a motion that's filed at any point that raises inability to pay as a basis for why this sanction should not have been granted?
Your Honor, yeah, the appellants did raise at the trial court level their inability to pay, and I believe that even in the extensions sought by Mr. Johnson, when he would send in letters to the court asking for additional time to obtain counsel, he would cite, I'm trying to raise money for a retainer for this attorney, and then he'd end up getting a different attorney. But I would point the court to the fact that the withdrawals themselves never specifically cite to that, and there's no affidavits in the record indicating proof of an inability to pay. And that was specifically brought up during the motion to alter or amend portion of the dispute at the trial level. Now, you asked the question earlier, the standard of review, and as it relates to the overturning the motion to alter or amend, and as it relates to a decision based on 1606 sanctions, both are under the standard of review for the abuse of discretion. Given the tortured history of this case, I think the court was certainly within its discretion to make these decisions that the court ultimately made. But moreover, as it relates to the excusable neglect portion, where the appellants seek relief, I disagree with the position that the appellants put up a meritorious defense. Case law indicates that legal conclusions, just simply making a statement that something's not true, is different than actually having a meritorious defense. So an answer filed back in 2017, and the fact that there's also not an answer filed for the amended complaint until after the motion to alter or amend hearing, beyond that, looking at just legal conclusions from an answer filed back in 2017, I don't think amount to a meritorious defense, even if the failure to pay, as positioned by the appellants, is in fact found to be excusable neglect, which I would argue that it is certainly not. Then lastly, looking at the motion for summary judgment and the decision, the court did in fact find that this would be an injustice to not allow Barron to pierce the corporate veil. This is one of those cases that kind of blew me away, that you just take the different Allen factors off, and they satisfied them. But the injustice comes when the fact that you realize that 4J Construction Company, the contracting party with Barron, wasn't even existing at the time, and Barron didn't discover that until after the fact. So who are they going to go at? Where are they going to get their money? They've got this judgment, and it would be an injustice not to allow them to recover against Push 4J and or Lafayette Johnson individually, especially given Mr. Johnson and Push 4J's incredibly tight relationship.
Thank you.
Thank you.
I would also like to clear up some facts real quick. Appellee is mistaken about the absence of an affidavit or any other proof in the record about the defendant's ability to pay. I would direct the court to page 356, which is in volume 3 of the record. This is an affidavit of Lafayette Johnson that was signed on March the 18th of 2020. And in that affidavit, Mr. Johnson states that he previously hired Bede Anyanwu to represent him and his companies, 4J and Push 4J, in this litigation. Dr. Anyanwu withdrew from representing him. He immediately began searching for alternate counsel, calling numerous attorneys in the Nashville area. However, all of them wanted significantly more money up front than I was able to pay. He goes on to talk about trying to hire Elizabeth Tipping, but he didn't have the full amount at that time.
Counsel, did the chancellor make a determination that Mr. Johnson wasn't acting in good faith in this case in terms of how he was proceeding?
The chancellor, if I recall, made a statement or a finding that I don't know if it was termed as acting in bad faith, maybe had abused the process. I cannot recall the exact language, but there is nothing in the record that would suggest that the defendants were acting in bad faith or were intentionally abusing the process. The record would actually reflect that the defendants were
Well, what about
diligently.
the claims of discrimination made in the counterclaim and then not really putting any proof forward in the responses to
I
discovery?
think Mr. Johnson genuinely felt like he was being discriminated against. And although there was no actual proof, it was a feeling that he was getting from the prime contractor. And I don't want to say that that was not a feeling that he should not have been having. He just did not have the proof to support a racial discrimination claim. But it doesn't mean that he wasn't getting a certain feeling or vibe from his employer, the prime contractor, that would suggest he was being discriminated against. Thank you.
Thank you. Thank you both. Would you dismiss court, please?